The Texas Government Code is amended. I call an order meeting of the Board of Trustees of the Austin School District for Monday, February 20th, 2012 at 6:35 p.m. The board may meet in closed session to deliberate the appointment, employment, evaluation, assignment, reassignment, duties, discipline, or dismissal of public officer or employee, deliberation of purchase, exchange, lease, or value of real property, deliberation of negotiated contract for prospective gift to the district, deliberation about commercial or financial information the board has received from business prospect, or deliberation of the offer of a financial or other incentive to a business prospect, and or to consult with legal counsel regarding pending or contemplated litigation on or settlement offer or on a matter which the school's legal counsel determines to be confidential in accordance to Chapter 501 of the Texas Government Code, Sections 551.074, 551.072, 551.073, 551.087, and 551.071, respectively. Welcome, everybody. We need to scoot to the, we have a motion to approve the agenda.
That's great. I move approval.
Is there a second? Second. All in favor of that motion, please raise your right hand. Passed approved. Unanimously for members on the dais to do the pledge. Ms. Moya.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Welcome, everybody. Several interesting topics on tonight's agenda. We're going to start out first with the school finance litigation update. We have an hour scheduled for this item. Dr. Christarfin.
Mr. President, trustees, on October 24th, the board approved a resolution authorizing the district's participation in a school district lawsuit, a finance lawsuit, which was filed on December 22nd. This is one of 4 school finance lawsuits to be filed in recent months in the wake of the significant reductions to state funding for public education during the last legislative session. This evening, lead counsel David Thompson will provide an update on the litigation and answer any questions the board may have. Welcome, Mr. Thompson, and feel free to jump right in.
Good evening, members of the board, Superintendent Christarfin, and others. It's great to be with you tonight. I appreciate the opportunity to come and give you an update on the status of this litigation and have some discussion in public that will be similar to conversations that we've had in private. I would first like to introduce Holly McIntosh, who is an associate in our Austin office here. She has extensive background in school finance, having worked in the Capitol for Representative Scott Hochberg for 2 sessions. She is able to do modeling, and she's also worked in litigation in the Attorney General's office for the past 2 years, and we're happy to have her on our team. I will assure you at the outset, I will not filibuster. I know you've set aside an hour for this discussion, but I also know you have other important subjects on the agenda tonight. I will try to keep my remarks relatively brief and then spend the majority of our time responding to any questions you may have. As already has been said, 4 different lawsuits have been filed. There are rumors of a 5th lawsuit. If it develops, we'll see in the near future. But of the 4 that have been filed, they have all been consolidated for purposes of trial and assigned to Judge John Dietz, Travis County District Judge. We're very pleased with that because Judge Dietz was the trial judge last time and already has significant experience and familiarity with the issues, and we hope that will expedite the trial process. All of the different lawsuits are working together. The attorneys are talking on a regular basis. We will be submitting a joint proposed scheduling order in the near future. We know this is a matter of great urgency to districts, and we are approaching it with that same sense of urgency. We will be asking for a trial date this fall in October, with the expectation of completing trial and hopefully getting a positive decision at the district court level prior to the beginning of the legislative session in 2013. So we're going to push hard on it and try to get a resolution sooner rather than later. That's the way we will approach it, and all of the groups are working together on that. I do want to let you know that our group, the Fort Bend ISD group, they're the lead name district, but Austin is one of the very important, significant members of this group. Our group is composed of both Chapter 41 and Chapter 42 districts working together. We currently have over 1.8 million students that are already members of our coalition, with more joining literally on a weekly basis. And just to put that in perspective, this is far and away the largest of the different groups this time around. In fact, our group in terms of students is larger than all the other groups combined. And it's the largest single group there has ever been in the history of school finance litigation in Texas. So it's a very significant presence, and we think that alone makes a statement. I think by the time we get to trial, well over half of the districts in the state and well over 2/3 of the students in the state will be participating in one of the different groups. So we're going to coordinate. We've already got a trial court assigned, and we're pressing for trial sooner rather than later. And so just from a status, that's a quick update in that regard. Mr. President, Madam Superintendent, I have a PowerPoint. I think, have you all been provided copies of this? I'm going to hit a couple of the slides just to make some observations, and then again, save most of our time for any questions the board might have. Holly, if you'd hit the next slide. Yeah, just hit the advance button. This is just the point I want to make here is if you look over the last 30 years, we see a pattern in Texas. I wish it weren't this way, but it's almost sort of a call response, point counterpoint pattern of virtually all of the significant changes in school finance in Texas over the last 3 decades have come as a result of a court decision. In the last 30 years, we have had 6 cases get to the Supreme Court. This will be the 7th. I'm confident it will reach the Supreme Court. Out of the previous 6 cases, the state has prevailed exactly 1 time. So we hope to continue that pattern, and that's our objective. But some people may say, well, why did we have to file a lawsuit? What is the lawsuit? Why are we doing that with regard to school funding? Why don't we just work with the legislature, or comments of that matter? The only point I want to make here is, for whatever reason, this is the way we tend to do this in Texas. The observation I've made to a number of civic groups when I speak about this is I ask people, I say, quick, don't look at your neighbor, give me an honest response. How many people have a 2-car garage? And usually most are greater, and usually most people will hold their hands up. I say, now don't look around, be honest. How many people, if you went home today, could get 2 cars in your garage? And about half of the heads usually go down. The point is, we all have fairly large, complex jobs that tend to get put off until we have to deal with them. And unfortunately, at the state level, I think school funding falls in that category, and I do think a decision from the Supreme Court will actually be very helpful to the legislature in making some significant substantive advances. Just keep hitting it till they all come up. As you know, the 2 key provisions of our Constitution that all of this litigation flow from, first of all, Article 7, Section 1 of our Constitution. Very important provision. All of Article 7 deals with education, not only public education, but community and junior colleges, higher education. That's what Article 7 is about. It starts with these words that have been unchanged since 1876. A general diffusion of knowledge being essential to the preservation of the liberties and rights of the people, comma. Now, just stop right there for a minute. That tells you why we believe in public education in Texas and why Texans have always believed in public education going back to the 1800s. That notion that an educated society and a healthy society are interrelated is at the heart of why we have a school system and an expectation for public schools in the state. If you continue reading, that section then speaks in language you don't see elsewhere in our Constitution. It shall be the duty of the legislature to establish and make suitable provision for the support and maintenance of an efficient system of public free schools. That's sort of the how, if you will. The why is because an educated society is essential to a healthy society. And then the how are the duties that flow from that to the legislature. And these are non-delegable, non-discretionary, they're absolute duties. A duty to establish, a duty to suitably or adequately provide, and a duty for the system itself to be an efficient system. Another key provision that we tend to talk about in Texas is Article 8, Section 1E, which prohibits a state property tax. And our court has noted many times, going back to the 1990s, that the legislature can run afoul of this provision by having a system that is so reliant on local property taxes that local districts, local boards no longer have meaningful discretion over your own taxes. And so my question that I ask many times to school districts is, how many of you felt like you had a lot of discretion this year? The discretion you had, I suspect, was simply what to cut out that your community thought was important. That's not what the Constitution has in mind. So this litigation flows from these provisions of our state Constitution. These are not new issues. Our Supreme Court has spoken to them many times in the past, and we're going to seek their interpretation and strong voice again on this. You can move past that. This is just language from the Supreme Court from the last time. Again, it isn't new. Our Supreme Court, by the way, in 2005, every justice that is still on the court who participated in the decision in 2005 ruled in our favor and participated in this decision. And you can see the language that it's the degree of state control over the local property tax, either directly or indirectly, and whether the local district has meaningful discretion. And I want you to read the key phrase at the bottom. This is verbatim from the Supreme Court's opinion. The state cannot provide for local supplementation, then pressure most of the districts by increasing accreditation standards in an environment of increasing costs to tax at maximum rates in order to afford any supplementation at all, and then argued that it's not controlling the tax rates. Our Supreme Court has spoken pretty clearly on this. We believe this is exactly what has happened if we look over the last several years, and that will be one of the key arguments that we will be focusing on. Just a slide that shows the distribution of tax rates in Texas. Let's move on. Another key issue that our court spoke to in 2005 that we will press heavily is the adequacy argument. So one argument, state property tax. A second argument is an adequacy argument that really flows from that duty of Article 7, Section 1 to not only have an efficient system, but to suitably provide for that system that you've just created. And our view of the adequacy argument, just to be clear, and I think we've had this conversation previously, we're not asking the trial court or the Supreme Court to invent out of thin air how much they think is enough. We're not asking them to just kind of be an activist court and to take it upon themselves to identify how much money or how many resources ought to be devoted to public education. Our argument is that the state has already defined a very high standard of expectations for school districts. When we look at the recommended curriculum, when we look at the end-of-course exams and STAR exams that are being phased in, when we look at the 4x4 commitment, post-secondary readiness, all of these requirements together, and indeed, if you look nationally, Texas gets relatively high marks for setting high standards or setting high expectations. The adequacy argument is once we set the standards, we have to have a funding system that actually supports and is tied to the very standards that the state itself has set. We used to do studies in Texas at the state level to determine the cost of our own requirements. We stopped doing those studies several years ago. Why did we stop doing the studies? Because they didn't like the answer. Our own studies and the state's own studies kept saying over and over, if we're going to get a growing population to high standards, it's going to take some resources. We simply quit doing the studies. It's sort of like a person stopping going to your doctor because you just don't like the advice or the diagnosis that you're getting. We're going to try to correct that. But that's all we mean when we talk about adequacy, is take our high standards and then have a funding system that actually rises and is tied to our own requirements. Next slide. Just a quick observation. When we talk about adequacy, I just think this is good information for everyone to keep an eye on. If we go back to the last Supreme Court decision in 2005 and then pick up with the school year, the next school year after that, and just look at what has happened to our demographics in Texas, it's pretty amazing. When you look at our demographics, we are a dramatically growing state. We're adding roughly 85,000 students a year. Not quite as many as Austin ISD, but close enough for the example to, I think, be apt. We're also a changing student population. If you look at where the growth is in our student population, we're getting high, our population is getting bigger, and it is simultaneously changing, and that's obviously putting demands on our schools. I visited recently with Dr. Steve Murdoch now at Rice University, formerly the state demographer, and then was also director of the census at the national level under President Bush. And he has written extensively about demographic changes in Texas and published a book regarding that in 2001, right after the 2000 census. And I asked him what trends he was seeing as a result of the 2010 census. And he said, what I projected in 2001 and 2, I was wrong. I have to admit I was incorrect. And I said, oh, really? How were you wrong? And Steve said, well, I was wrong because the pace at which I thought Texas was going to change, I completely underestimated. We are changing much faster than I even projected a decade ago. And you see that when you look at our statistics. If you want to know what Texas is going to look like 10 years from now, look at our school population today. And every one of those kids shows up expecting a great education, and obviously that's our job to deliver that. Next slide. We also are in an environment of rising standards, and go back and think about that language from the Supreme Court. We have set standards in Texas that we expect of all schools and all kids. We need a funding system that supports that. Next slide. The real growth in our state has been in our disadvantaged population. If you look at total enrollment, over the next two slides, you will see the extent to which our economically disadvantaged population has grown. This slide in particular makes, I think, a very compelling point. If we look over the last decade, our total school population has grown 21.2%. Our economically disadvantaged population in the state as a whole has grown 45.5%. And I'm sure you're seeing those same trends here in your community. And so those are expectations. At the same time that we're raising standards, we are dealing with a growing, changing population. And frankly, meeting that need is going to require some resources. That is our adequacy argument. Very quickly, the next couple of slides, I don't know why anybody would say this. There is I've heard some state officials make the observation that they actually increased funding for public education this last biennium. Has anybody heard that statement? I am publicly inviting anyone who thinks they increased funding for public education to show up and take the algebra end of course exam this coming spring or here in a few months because their math skills are in question. if you look at the actual numbers, the all funds number for the last two biennium, it is clear we are not increasing funding for public schools. Keep going, next one, Holly. In fact, yeah, and in fact, it's very clear we've made significant cuts at the very time. I think it is a tragic convergence that we've made these cuts that are of historic significance at the same time that we're phasing in the new high standards in Texas. Quickly, next slide. I'll let you just look at these, some of the cuts in the special programs. Go on to the next one. You'll remember the Constitution uses the word efficiency, and that is also one of our arguments. The system has to be efficient. What do we mean by efficient? One definition of efficiency that our court has recognized is don't be wasteful. Be productive, be careful with resources. In my experience, schools are working hard to do that. Another definition of efficiency is a certain degree of equity. This is a statewide duty, and so the state has some responsibilities to make sure all districts have the resources to try to achieve that. But I want to make a real key point on the next page, next slide, and these are quotes from our Supreme Court, and look at them carefully because I think this is very important to Austin ISD and other districts. Our Supreme Court, as recently as 2005, said efficiency means that we level up to this concept of general diffusion of knowledge. And our own court said the effect of holding otherwise would be to level down the quality of our public school system, a consequence that is universally regarded as undesirable from an educational perspective. The point I want to make tonight is if all you're focused on is equity, if that's the only thing you're thinking about, you can increase the equity of the system by leveling down. Okay? You could do that. That is not what our Supreme Court has said. Our Supreme Court has said we level up to our own expectations, to the general diffusion of knowledge. We don't solve this problem simply by pulling the top down. And that is very clearly how we're going to approach this litigation. I want to make sure and make that point. Next slide. Our court has said very clearly the system is not supposed to be arbitrary. And then just quickly go forward right here. I just want you to read this. This is sort of the concluding paragraph in our petition, which you've all received. Hopefully you've had an opportunity to look at, but I want you to read it. The solution, as our Supreme Court has presciently warned, is not simply to level the system down to some predetermined funds available amount. The solution must be a rational system that both adequately and equitably lifts all schools and children to the high performance requirements the state has set, and that preserves meaningful discretion for communities to supplement the state requirement with choices of their own. By ignoring and understating the true cost of its own determination of general diffusion of knowledge, the state has harmed both the adequacy and the equity of the system and has cynically pitted school districts and communities against each other in a zero-sum conflict in which some only gain at the expense of others. This broken system simply does not meet the high expectations and clear duties of the Texas Constitution. So that's the claim. That's how we're approaching this. And I'm going to stop right there. Hopefully I didn't run over there, Mel. So that's kind of a quick highlight of our claims that we're working on. Again, we're now beginning the hard work of building out the factual and expert testimony that will support that. I frankly anticipate that Austin ISD will be a very key district and very key participant when we get to the trial court level, and so we'll be having further conversations about that. But with that, I will stop and see if you have particular questions. If you're hearing issues or questions in your community that we can respond to. And so, President, Madam Superintendent.
Thank you all very much. Just to note, board members, behind that, there are some results from a poll that was done to kind of give you a sense
Right.
of what the public's feel was about the public education
And,
cuts.
and we can put those up if you want to, if you think that would be useful. I think you've all seen them.
Just general consensus is
Right.
the public doesn't believe the cuts were good.
The broad consensus is that the public thinks the cuts to public education were a serious, tragic mistake.
That's more, that's stronger language than not good. So
Yep,
I'm with
it
you
is
on that.
not good.
Okay, let's open up for comments or questions. Thank you all for being here. Team? Okay, Mr. Schneider. Ms. Moya.
I'm going to go back to the same three things I seem to always talk about, which is the definition of equity that seems to be used by a lot of folks, mainly, and maybe even the legislature, which is that equity is dollar for dollar. I don't agree. I believe that equity should be the result of new, revised, and updated weights and allotments formulas, and a change in the cost of education index. When you're dealing with these things, and David, I know that you're very familiar with this, but when you're dealing with formulas and indexes that are 20 years old or older,
Yep.
you create an inequity for all school districts.
Right.
And as a result, Austin, over the last 10 years, has sent, $1.3 billion or $4 dollars
Right.
to the state, and it's not sent back to the state.
Right.
It's brand-new money to the state of Texas.
Right.
And I think that's something that's important for people to say, because a lot of times you hear all over the place, sending back to the state, no, it's not being sent back. It's brand new.
Right, this is the first time it's actually a hidden source of revenue to
Right.
the state. Right.
And so, this is, in my opinion, the way we're funding public education is, years ago, the lottery was supposed to help
Right.
fund the public education system. So what did the state do? The lottery contributes this much, the state pulls back the same amount.
Right.
And that's what's been going on for years and years and years. And I think the public needs to know that, and they need to understand what's going on, because it's, and so if there is a way that, as you all are working this, that those kind of issues can be brought to the forefront loudly and repeatedly, this board member would greatly appreciate it.
We concur with what you just said. I think, and I want to separate political arguments about equity. I mean, there will be legitimate arguments in the Capitol every time the legislature meets about what is fair, what is equitable, what is a fair distribution of whatever resources. Our focus in the courthouse is on the legal, judicially prescribed definitions. And our Supreme Court has pretty clearly said we're not going to adopt an all funds or a measurement of the top against the bottom standard. That isn't our standard. What our standard is you first start with, what's the target? If you don't know where you're trying to go, you're not going to get there. What is our target? Our target is a general diffusion of knowledge, which our legislature has defined as this set of high expectations. Our whole approach, and we believe this is consistent with what the court says, is that if you fund up to the standard, not a level down approach, but a level up approach, you increase both the adequacy and the equity of the system at the same time. And then local districts have room for supplementation above that out of your own local resources. That is the approach that we believe our Supreme Court has recognized and affirmed in its prior decisions. Now, to go to your second point, within our current structure, when you look at the weights, and particularly arguably the cost of education index, although I would argue probably the comp ed weight, given where the change in our population is, if you understate the cost of getting groups of kids to high standards, that is not only inadequate, that is inequitable, and it cuts across the wealth spectrum. You have kids with needs in wealthy districts, and you have the kids with needs in less wealthy districts. But to the extent that the formulas understate that cost, that harms all of those districts, and it's a disequalizing factor. So we very clearly are focusing on that, and in fact spent a good portion of today talking about and looking at some of the research and data around those issues. Thank you.
Mr. Snyder.
Mr. Thompson, a couple of questions, if I can. This has been going on for a number of years, as you pointed out, and it seems to me that we're actually in a cycle of districts filing suit against the state, the legislature wanting to do what they're legally required to do, but not necessarily step forward and say, this is what the standard is, this is the amount of money we need, and the court system unwilling to set a rigid standard that must be met in some form. And it just seems to be the same repeating cycle. So do you see an opportunity for the courts to actually step in and say, here's what the standard is,
Yeah.
this is what you've got to meet, and force the legislature to accurately meet funding? Or do you see it as the role of local trustees to be a little bit clearer in what their expectations are and get that message across to probably the state legislature, and then go from there with regard to implementation?
I think it's a balance of both of those. If you look at previous Supreme Court opinions, in all candor, I think you see indications that the court is sometimes as frustrated with this cycle where you have a crisis build, you have a cathartic coming together of districts, you get a decision, you get some kind of legislative response, and then the system sort of deteriorates, and 5 or 6 years later the cycle repeats. And so we've spent a lot of time thinking about how do you break that cycle? How do you put something in place from a remedy standpoint that will change the dynamics? And if you look at our petition, which we will be amending and expanding on before we get to trial, we've spent more time this time looking at remedies and thinking about those in addition to the claims. One thing we're asking for this time is that the trial court, at the conclusion of this trial, after the districts win, not if, after, that the trial court keep jurisdiction to oversee the implementation of a remedy. And and remember, our defendants in this case, it's not the legislature, it's not the governor, it's not those officials. Our defendants are the Commissioner of Education and the Comptroller. Why? Because those are the executive agencies responsible for the implementation of the system. One of the things we're going to be asking for is that those agencies be required to perform the studies that frankly should have been going on all along to determine the cost of the state's requirements using methodology approved by the court that involves our districts, and that those numbers be used in the development of budgets, recommendations, submissions to the legislature. I don't think the court will ever order an appropriation. I don't think the court will prescribe particular formulas. But what we can ensure, hopefully, is by keeping jurisdiction and tightly